every Thursday at 4 p.m. Pacific time, 7 p.m. Eastern, to help real estate agents, investors, attorneys, best practices in probate real estate. I was really excited the other day when I read, a couple weeks ago, I read in the news about an elder law abuse case victory for a local client and a local attorney. And the more I looked into it, it seems to be the kind of thing that we as realtors come across and we say, man, I wish there was some attorney that would be able to do something to fix this situation. In many cases, we can't. And I had the opportunity to reach out and speak to Bill Chapman, who's a local attorney based in Orange County, who helped this Long Beach woman get back money, or I guess really an award for $4 million or nearly $4 million. We're excited to have attorney Bill Chapman on the call with us. Bill, thank you so much for joining us.
Hey, good to be here, Bill. Thanks for inviting me.
So you are an attorney and you do more civil litigation is more the focus of your business, and this happens to cross over into elder law?
Yeah, my practice area was really business litigation, but I've been doing this for 40 years. So I started in insurance defense. I've done some plaintiff person injury, different types of law, exposed to family law, probate law, and so forth. So I know my way around the courtroom is probably my main claim to fame. And when this came up, I just, heard the story and it just really resonated with me. So I jumped in with both feet.
So we'll put the link to this particular news version from the Long Beach Press Telegram. And my assistant, Jess, on the call, she's from Long Beach, recently from Philadelphia. Long Beach woman thrown out of house, awarded $4 million in elder law abuse. And what also caught my attention in this case was that the defendant, or I don't know what the term would be, criminal, the object of the person who perpetrated the crime, the swindling, was a real estate investor, a pretty prominent one, who had all kinds of real estate underway. So this is the article that appeared, and you had a chance to talk to him. So can you kind of give us, and I know there's things you can talk about and things you can't talk about, so I don't want to cause any problems. We want you to be as successful as possible. Can you give us kind of what was about this case that got your attention, and what do you think the court ruled that verified your case?
You bet. Well, my client, Suzanne Jorgensen, is just a sweet lady. She's currently 80. At the time, she was 78 years old. And at the time of this transaction, she, a couple months before, it had a stroke and left her paralyzed on the left side. She also has bed sores, is bedridden, essentially, had been in and out of nursing homes for the prior year or two. And she had a home 6 blocks from the beach in Long Beach, in the Alamedas Beach area, for those who know that area. And it was an older home, but she had owned it for almost 50 years. And she had let her, since she went before she went in the nursing home, she had allowed her sister, a mentally disabled sister, to live in her home. And then she also rented out the garage to a kind of a handyman that I think was just kind of a freeloader, but paid her $300 a month rent. But anyway, she got a notice of default from her bank, and she panicked and thought, oh my goodness, she's a layperson. She thought this letter meant she's going to imminently lose her home. By the way, it was valued about $800,000. And she had owed about 40 grand on it. So obviously had done some refis or whatever, but still very, very little owed relative to the equity in the home. She panicked and said, oh my goodness, they're going to foreclose. They're going to come in tomorrow, sell my home at a fire sale. They'll take all the money. I get nothing. My sister's out on the street. And so she told this handyman, or he brought the letter to her in the nursing home. And she opened it up, looked at it, and she said, well, what do I do? And she knew that he worked as a handyman for a wealthy real estate investor. And she said, hey, can your boss help me in some way? Maybe give me a loan or do something to save this home. And he said, well, I don't know. Let me set up a call. Her cell phone was dead. She didn't know how to fix it. So he loaned her his phone, and she ended up on a cell phone call for all of about 5 or 10 minutes with this wealthy real estate investor. who owned 31 properties, primarily in Los Angeles County, but a few others around the country. And in the conversation, she asked him if he could help. He said, well, no, I don't think I can give you a loan, but I might be interested in buying your house. His pitch to her on the surface, well, at least to her, sounded not only reasonable, but she called him her savior. She said, oh my goodness. He said, I will let your sister live there for life, but I'm going to have to fix up the property. I'm going to have to get a loan. Now, the guy's worth $30 million, but he said he had to get a loan on it. So he had to fix it up first, get a loan. And to get the loan, he said he'd have to get a renter in there. And he said, your sister will be in part of the house, we'll rent out the rest of it, and that rent will pay the loan back. So that allows me to do this thing. And she said, oh, you're just the most wonderful person I have ever met, and that kind of thing. And so he said, well, I'll have my lawyers drop some documents and, formalize this and whatever. I think she had a couple of calls with him, about 10 minutes total or something. Well, one day a notary shows up in her nursing home and says, I have a paper for you to sign. She says, well, what is it? He said, I'm a notary. I can't talk about it. I just got to look at your driver's license, get your thumbprint and so forth. And she thought the handyman had told her that this nice guy, this investor who's going to help her out, had actually already paid off her mortgage. So she thought, oh, he paid off my mortgage. He wants some note from me saying that I owe him this money, or if I die, he'll get the money back. So, and she couldn't really read very well. She had glasses, but she didn't have them with her. So she went ahead and signed this, what ended up to be, of course, a grant deed. No promissory note, no purchase sale agreement, no trust deed, no escrow, nothing. And so she signs this not knowing what she did. And then she just, she's bedridden. She's sitting there in the nursing home. And then what happened is, once he got title and recorded it, he went in there, and sure enough, he started doing his so-called repair work. Didn't have licensed contractors. He's not a licensed contractor. Didn't pull permits. Just started, patchwork, doing some whitewash painting, some really, really superficial type repairs. And then he told the sister that he now owned the property. Now that he's fixed it up, he said, I own the property and we're going to evict you. And so the sister, who is mentally disabled, just went berserk. She got in a Camaro car, old Camaro car that she had in the driveway, and started driving around. She went to the public library, looked up the names and phone number of a long lost cousin that she remembered, and miraculously calls up this number and gets a hold of her long lost cousin she hadn't talked to in decades, and said, hey, can I come see you? They said, okay, come on over. Yeah, we remember you. Come on over. She went over. They lived in Huntington Beach. She told them what was going on, and they said, well, let's go find out. We need to do a little investigation. They actually had a friend who was a real estate broker who looked up the property, and sure enough confirmed that this guy had a title to the property. So they met with my client in the nursing home, said, hey, we need to get you a lawyer. This is really bad what's happened. You no longer own your house, but we want to try to get it back for you. And she said, okay. So they became the guardian ad litem for my client, and actually started funding. I know, Bill, when you and I spoke, one of the questions of these cases is, this lady has no money. There aren't many lawyers who will take this type of a case on a contingent fee, especially with a wealthy real estate investor who's going to hire the best lawyers he can find and just dump unlimited money to bury the little lady who can't afford to really litigate. So these cousins, fortunately, they had the resources to retain us, and initially paid us hourly for the work, but it didn't take too long where they said, oh, this is getting really expensive. And we said, yeah, okay, well, we'll switch it to a hybrid. So we did that. We lowered our rate and took a little contingent fee. And then after a little while farther, they said, we are really This is really expensive. We're getting into expert witnesses, getting ready for trial. And by that time, I like to find out, there's always two sides to a story. So we did our discovery, and just, the defendant was just a crook. That's what we call him, is a crook. And
Is that a special legal term, crook?
yeah, it is. It is. You can call him defendant or whatever you want, but I just call him a crook in a suit, maybe. But anyway, he hired a law firm. He just started. In fact, I called them as soon as they made an appearance. I thought, well, maybe they've got a lawyer who's going to, be reasonable and understand the writings on the wall. And so I asked him if they wanted to talk settlement. And he said, oh, well, yeah, we do. We would like to talk settlement, but we need to do discovery first. So I knew that was code word for we're going to try to bury you in discovery. And I said, okay, well, I know how to play that game. Let's go do some discovery. So we went through all these depositions of precipient witnesses. And then they called me and said, oh, we've done all these depositions now. Are you still interested in talking settlement? Oh, back up one. Early in the case, I also wrote a demand letter to, once he got attorneys, we wrote a demand letter, which is pretty typical. And we set forth all the factual background, the documents or lack of documents. And we itemized our claim for damages under the elder abuse statute, common law fraud in the inducement, and so forth, and so forth, and attorney's fees under the statute, doubling of the property that was taken, and so forth. And we came up with a demand of we said, if we go to trial, we think we can get $8 million, but we are willing to compromise. We'll settle for $6.5 million. And their response was, well, we will give your client the house back, but she's got to pay $260,000 for the defendant, the crook, claim that he spent that much money in these repairs. And she didn't have the money and just said, there's no way we're going to, and the cousin said, no way we're going to do this. So, their little offer was just phony. So we went ahead and did experts. We did written discovery, document production, subpoenas. I even subpoenaed he got a bid from a contractor, a general contractor, for $265,000, claiming this was the work that was actually done. Well, problem is the bid was in August of 2022, which is after all his work was done. The transaction was January 31, 2022. He started work in February, finished in August, has a bid in August after the work was done. So I called up the contractor and eventually subpoenaed him, talked to him, and I said, what is this bid after the fact? He said, oh, well, I'm a tenant of this gentleman, the defendant. He called me up and asked me for a favor, said he wanted me to prepare a bid. He didn't say it, but I think he probably told him the amount that he wanted to bid. And the guy, did this fully loaded bid on this work, never went to the property, didn't do any work on the property. And then I asked the defendant for all his records for this so-called work, because my broker had gone out there. And like those of you who are brokers, how to look at a property and probably know if there's been repairs. My broker's friend said, hey, you give me $100,000, I can fix any house up to get it ready to sell. You don't need $260,000. That's outrageous. Then he went out there and he looked at it. He said, Bill, they didn't spend anywhere near $260,000. That would have been a beautiful remodel, state of the art, top of the line. This is just a bunch of patchwork. And so then I hired a general contractor, licensed general contractor, expert witness, went out there, took pictures, took his tape measure, measured everything, got an appraiser out there and so forth. And the general contractor went through what he saw, the work that had been done and the quality or lack of quality. And he said the value of the work, if you hired handymen, which is what this guy really did, was about $60,000, not 260, but $60,000. So we presented all of this evidence at trial, and it was evidence we felt of not only, that he transferred this property improperly, took advantage of the lady, but he did it maliciously. He lied, and in fact, he was lying in court. I caught him cross-examining him. Was amazing because he had written discovery responses or had his pleadings. He filed a cross complaint against my client for what he claimed was $260,000. And at trial, I started cross-examining him on this work and his claims. And he said, "Oh, I didn't read that." I said, "Sir, you signed this under penalty of perjury relating to a case in a court of law. You're telling me you did not read that before saying, 'Oh, my lawyers, they handled that. I just sign it.'" Oh, I mean, he just went down really fast. Now he started. Sorry, I'll wrap up this long answer to a short question. But the guy took the witness stand. In fact, when I deposed him, I told my clients, this guy is going to be tough to cross-examine. He walks in the room, shakes everybody's hand. "Oh, how you doing? Oh, yeah, how many kids do you have? What's your family?" This guy is a schmoozer, but he was really, really smooth. He seemed like a really nice guy on the surface, one of these, wolf in sheep's clothing. And so anyway, it was really a battle with him. He started his direct examination saying, "Oh, I have terminal cancer. I have a son who's disabled. When I found out about this situation, the lady had her disabled sister. It just tugged at my heartstrings. I wanted to help her. I didn't need the money. I just, wanted to help her out." But in the end, there was just an avalanche of evidence. Why didn't you have, if you promised to pay $300,000, why didn't you sign a promissory note? Why didn't you sign a trust deed? Why didn't you have a purchase and sale agreement? You've bought 31 other properties. You're not a novice at this. He said, "Oh, I need you would need a broker to do that. And I'm the buyer and the seller gets the broker." And I told her if she got a broker, it'd cost her 30, 40 grand and she didn't have any money. So he said, "I have an alternative. I'll handle it myself and you can save the money." So he just totally hoodwinked her on the whole thing.
Wow. Well, obviously there's a lot to unpack, and just those of you on the call, this is meant to be interactive. Feel free to raise your hand, put a question in the chat box. We're streaming this live on YouTube, Facebook, and LinkedIn, and I see we have a nice following there as well. So if you have questions as well, I'm monitoring the chat boxes. Feel free to put questions in as well. So, wow, there's a lot to unpack there. Most of the people on the call today are real estate agents. One of the things that struck me was this guy's a realtor, yet he's buying it as a principal, yet he didn't have any kind of contract, let alone a standard CAR form, California Association of Realtor form, or some sort of a template form you might buy at Office Depot. The only documentation he had on the transfer of property was the grant deed, correct?
Yeah, exactly.
So to me, that's a red flag right there.
Yeah.
Right. Number one. Number two, I pulled the file up and there was no title insurance, right? Because there'd have to be some sort of proof of who she was and documents and such. So his intention was, I guess all along, to transfer the property and hold on to it, either rent it out or something along those lines. He had no, it doesn't seem like he wasn't looking to flip it. This is a wealthy guy doing this. This was not some fly-by-night operator.
No. And you're right. He had a history of his properties. He was buy and hold and rent them out. That was what he did. In fact, he even said in trial, I asked him what, in his deposition, then again in trial, what his style of investment was. He said, "Well, I like to buy when property values are depressed." And so I thought, well, yeah, that's what you did here. You heard of a little old lady who's got a notice of default, right, and she's in a nursing home, paralyzed on one side, bedridden. So you decided this is a property you could get at a low price.
Right. And I think this is one of my challenges with distressed properties is it's one thing when it's an out-of-state owner and they have a bunch of properties and they don't be bothered with it and they're willing to sell it at a discount. But this is really, a lot of the distressed properties really take advantage of these situations. And so that's why I was really excited to bring it to your attention. Second, what clues, if I was a real estate agent and I come across this deed, what clues would you say to me as an attorney would be clues for me to be careful? Maybe this person isn't capable of making the right decisions, right? At some point, this case comes down to, even though she signed something, she didn't have the capacity to understand what she was doing, and she was misled. He said one thing, yet in real estate, it all comes down to writing. So at some point, the court must have assumed, I think, that the client wasn't capable of making own decisions. Is that a fair assumption?
Well, that was an interesting issue, and the answer is a little nuanced because my client was, if you talk to her, she's lucid. In fact, they did an independent medical examination with a psychologist who does this for a living, is an expert in this field, and he concluded that she had capacity. Well, my cross-examination of him was, doctor, you said you did this, and I was at the examination, so I knew what he did. Said, you did this examination, you ask her questions like, what day of the week is it? Do you know what your name is? Who's the president? Count to 5 frontwards and backwards, name some cities, what are your favorite animals? And he said, yeah, I did that. And I said, so you ask her questions like, what are your favorite animals, and name off some big cities that you know of. And from that, you concluded that she understood the fair market value of her home. She understood her options as having, 90% equity in this property, and whether she needed a purchase sale agreement, a promissory note, a trust deed. You concluded all of that from this examining. Oh, well, that's beyond the scope of my retention in this case, blah, blah. But I find that she had capacity. So he was playing word games, semantics, and that is, she had capacity at a certain basic level, but she did not have capacity to understand what the kind of representation she needed.
Right. Like under the law, a 17-year-old might have capacity intellectually, but we don't allow them to make real estate transactions because they don't have the capacity to understand really what they're doing. In this case, the doctor is saying she has a capacity to understand certain facts, but she has just enough capacity to be misled by a guy like this. What weighs in, if anything, the fact that the crook, to use your legal terminology, is both a sophisticated investor and a real estate broker, licensed and educated, versus your client who is a layperson? How much responsibility does an investor have when buying from a layperson and or a real estate agent when acting as a principal buying from a layperson? Now, did they have special obligations and certain risks in those kind of transactions?
Yeah, and that's another excellent question that did come up because the issue of what duties the buyer, this crook, had to the seller, legally, there's really no duty on a real estate transaction, as you guys probably know, between their adverse parties. But the real issue, the way we framed it in this case and under the elder abuse statute, wasn't that he breached a common law duty or other statutory duty like that, like a fiduciary or something like that. He had no specific duty in that sense. However, under the statute, it's actually a very, very strong statute to protect elders, and that is if a person is 65 years or older, and this is California law, maybe different other states, but 65 years or older, and there's a lot of different ways to show things called undue influence and so forth. But if you boil it down to the easy path to show elder abuse, the only other thing you have to show is that the defendant knew or should have known that the transaction would be harmful to the plaintiff. And the way I did that, the way I saw the easiest path to prove that was exactly what you said earlier, Bill, the lack of documentation. She had no protection. I said, what he said he paid $300,000, but he said I had to fix up the property. I had to get a renter in there, and then I had to get a loan and so forth. So what is the date for that? What is the due date for that payment? There's no specific date. And so when it's not in writing, it's amorphous like that, you've got nothing. She's unprotected. So I argued that the sheer lack of documentations alone was sufficient to show that she was harmed by this transaction. And because of his expertise, he knew it, or should have, at very least, should have known that. Now, he wasn't actually, I should clarify, sophisticated real estate investor, not a licensed real estate broker. So he always had brokers, and he said, well, the seller always gets a broker and we just share the broker or whatever. So he pawned that off. But it was enough to show his sophistication, because when you do 31 transactions and you have ongoing rents coming in, lease agreements, and you're, getting new tenants and you're doing repairs. This guy had been doing this for 20 years, so he knew what he was doing.
Right. So if you could just repeat one more the standard, or if I could summarize it, 65 or older, the defendant, if you're buying a property from somebody, if you should know that it's harming the person you're buying from, that could be determined elder abuse, just that alone. Which sounds like almost any distressed property, almost without fail, is that undue harm, right? It sounds like you're using that leverage, that situation.
Yeah. And obviously the key, I think, going back to an earlier question, I think the real key here to why he went down, and particularly with the fraud and all myelosuppression, was because he discouraged her from getting representation. And if she had had representation, all this would have been documented. Could have been,
right.
A real estate broker is not going to let their seller agree to accept payments in the future in this amorphous way, and nothing is in writing.
Right.
It was just wholly undocumented, which left her completely exposed.
I have to say, in my career, I can't think of an exception when a client has brought me a transaction they were ready to sign, where there was no agents involved. It was always a disaster, without exception. And the reason why the investor's pressing them to sign right away is always, well, if you don't do this right away, I'm going to back out or whatever. Yeah. It's because the deal is so bad that once anybody looks at it, it's going to fall apart like a house of cards. At least that's my experience.
Yeah. In fact, another factor that we mentioned bears repeating, and that is the fact that she had a notice of default. She's in a nursing home. She's bedridden. It creates a distressful situation, not just the marketplace, some kind of distress on the marketplace, but her personally, her life. She was in a very emotional state. And as a disabled sister living in the home, things like that, all of these factors show that I think heightened that responsibility. But again, key would have been to have, if she had had representation, if he had either paid for somebody or got a lawyer for her. And, there were a lot of other options, but he decided to just go for it and tell her, don't bother hiring anybody. I'll take care of you and save you some money, is what he said.
Now, I don't know that you would get involved in this, but maybe you do know. I imagine a guy who does this once does it more than once.
Well, yeah, that's another question everybody asks me. And because of the way these cases are handled, judges typically will constrain you to the facts of your case. And for me to go out and try to do discovery on 31 other properties would have been extremely expensive. They would have fought me on everything. So we didn't go into all of that. But I think the jurors were certainly thinking about that. I know people that I talked to about it. My wife is convinced, oh, this guy, if he did it here, he's done it to lots of people.
I would think other people in Long Beach could give me a phone call saying, can you take a look at this real quick for me? Or somebody should be doing that for you. Maybe I'm going to go research those cases and bring them to you for a finder's fee or something. Yeah. Give me, you talked about it in the first question, but just to understand, I get phone calls from people who have facts similar to this, not the exact same and maybe not as egregious, but similar. And it's a case where I say to them, listen, this is litigation. You have to hire an attorney. You have to pay cash out of your pocket, most likely. And I say, it's probably going to cost $100,000 or more to get to a trial, not to mention if you win and the other party appeals, that's a whole nother level of expense and such. Is that a reasonable range? Am I giving people fair business advice, not legal advice, but business advice in that case? Yeah,
you're probably low. The cost, is going to be several $100,000. If now again, everything is relative, and if we, like the demand letter we did, if they had been reasonable, the attorneys had advised him properly or whatever, he came to his senses, and we settled early, it'd be a lot less than that. But to take it all the way through the written discovery, experts, and fighting every step of the way in a jury trial, it's going to be multiple $100,000, unless you can find an attorney on a contingent fee, which, like I say, they're few and far between. I don't know anybody that would take this because there's a high risk. The lawyer has to do all the work up front. And even though it looks like a great case, you don't know what a judge or a jury is going to do with it. And so you have to, instead of getting paid every month, you have to postpone until, and now after the trial, we have to go through an appeal. It's another year or two.
Right. And I think that's the thing, customers understand that there is litigation routinely done on contingency, most likely automobile accidents, employee injury cases. But there's kind of standardized case laws, standardized insurance companies. There's kind of a range of settlements kind of preset, and each case looks kind of the same. This is so varied. There really isn't a industry that would take this on contingency unless you happen to know the attorney or somehow you catch him on the right day or tug his heartstring. I don't know of any that would take a case like this on contingency. And that's why when I heard about your case, it made sense. So they put some money up, took it to a certain point, and then it had to become a contingency eventually anyhow, I think. Yeah.
And Audra asked a question, did the client have any other relatives? Another good question. Not real. Well, she had a sister who lived in Nevada, but her sister had financial difficulties. So she really had no one else that could help. In fact, she fortunately found this one cousin and his wife who had the resources and were willing and able to help. Ironically, the defense lawyers tried to turn the guardian ad litem and his wife, who were there in the courtroom, into the bad guys and said, we wouldn't be here if these people weren't, trying to drum up some litigation and get rich on this case. And they've loaned all this money and they're going to get paid back some money, on this. They're going to get their fees paid. And I said, ladies and gentlemen, are you kidding me? These people are ones that finally helped. Yes, they put their own hard-earned money on the line and they may get nothing back, but they did it out of their heart because of the love for their cousin. And they actually are standing up and helping and now they're condemning them. This guy does not get it.
Right. And
I think that just inflamed the jury more.
They're the hero. If there's a movie of this case, they're the heroes, I think.
Yeah, exactly.
Well, you, and
well,
we have Matt Damon or somebody good looking play you. It'd be hard to find a good looking actor for you, but I think the heroes would be the cousins who put the money up. Otherwise, this doesn't get very far.
Oh yeah, they were great witnesses, and they are the real heroes here because they took a risk and they found a lawyer that would be able to help them.
So again, kind of outlining a movie here because the story is so interesting. Leslie asks a bunch of questions. Was the sister able to come back in the home, or where did she end up, the disabled sister?
Well, yeah,
this is nothing.
Oh, sorry. Go ahead. Go ahead. I'm sorry.
Okay. Yeah. So looking at the question from Leslie, was the sister able to live in the home during this time, or did she have to move out? Great question. And that is a point they made. The sister actually is still living in the home and never got formally kicked out. They threatened her, and then they got the cousin, and then we filed the lawsuit and started that. And so they claimed that one of their defenses was, hey, the defendant said, I was trying to help out. See, I never kicked her out and left her in there. And we said, well, wait a minute. He didn't kick her out in the beginning because he had to fix it up to sell it. And then he threatened to kick her out. And then the cousins got involved and it kind of exposed him. So he certainly wasn't going to do that. Now, one interesting other fact is 10 months into the litigation, after we had already filed a complaint and litigated the case, their attorney wrote us a letter. He had never paid the money, the $300,000. He said, well, I had to fix it up, rent it out, get a loan, and I never got that. So they said, we don't think he owes anything right now. But to try to resolve the dispute over the purchase, encloses a check for $300,000, which he said he didn't have a year earlier. But once he got sued and the spotlights on him, he all of a sudden came up with $300,000. Of course, he had the money any day of the week. But the letter said this is to complete the purchase of the home. Well, at trial, I blew that up and showed that to the jury. And I said, look, they claimed that the reason he couldn't pay more than $300,000 is because he had a disabled sister in the home. And so it devalued the property. Well, his letter with the check doesn't say that the sister gets a life estate. There's no promise of that. So they're still planning on booting her out. Oh man, they couldn't recover from that. Then I think there's a couple other questions. Did they ever come back and try to settle again? They did, but it was very, very weak effort. Again, what happened was they came back and said, "You want to talk about settlement?" And I said, "Well, yeah, but now we've been through all this litigation costs and expense." I said, our original demand was 6.5. I said, "We will come down from that, but not a lot. And if you come in and want to do a mediation and lowball us, we're not even interested. We're not going to do that." And then they responded, their lawyer wrote me back and said, "If you'll agree that your 6.5 demand was rather high, we'll agree that our walk away thing was rather low." And I said, they still don't get it. And I wanted to go to trial on a case like this. I thought this is one. Oh, we got a
we got a Zoom bomber
bunch of
here.
stuff going there. A
Yeah,
spammer.
I'm sorry about
Anyway, but back to the question. So they did. Oh, the final judgment is another question. We have a judgment right now of $4,659,456, but we are also going to be filing a motion for attorney's fees and costs. And the judgment, although the monetary judgment doesn't include the fact that the judgment also says the judge made an order and a finding that the grant deed was null and void and unenforceable. So the property comes back to her. The current value, our appraiser said is $850,000. So if you add all that up and what we anticipate will come in attorney's fees and costs, it's going to be in the neighborhood of $6 million or more.
Wow. Now your trial is purely civil, right? Damages
Right.
and
Right.
Is there a criminal element? I mean, is there anybody here paying attention saying, well, look what this guy did?
Yeah.
Is there a crime involved here, or is it just kind of not really, or we're busy with other stuff?
Yeah, I talked to a friend of mine who's in the DA's office in Orange County. He wouldn't be prosecuting it. So he's a good friend of mine. So I ran it by him and he said, "Bill, the DA is probably not going to prosecute this guy." I think the reason is because although in civil court, we were able to present all this evidence and convince a jury this guy's a crook. In a criminal trial, he's going to say, obviously, they have a higher burden than we do in civil court. They have to prove it beyond a reasonable doubt. And so they're going to get him crying again on the witness stand. "Hey, I was trying to help her out. I didn't kick the sister out. I really meant well. The problem is what they should have done in this trial, and I think a good criminal defense lawyer would do with him, is say, just confess. Just say, I was wrong. I shouldn't have done this. He doesn't have to say, I intended to steal from her. But what he should have done is said, "Oh, I really screwed up. I should have documented. I should have had her, got a broker for her. I did so many things wrong. I'm so sorry." He should have, if he came to me at the beginning of this, I would have said, "I want you to sit down right now and sign a grant deed back to her. No questions asked about paying this $260,000 back. Just deed the thing back to her."
Right.
Boom. But he didn't do that. They played this kind of hardball, hard to get cat and mouse game. And a lot of lawyers do that. They got paid a lot of money. He's a narcissist, so he wanted to, have his cake and eat it too. And I think it just, the world caved in for him.
So just a quick kind of housekeeping where we're at today. Really fortunate to have with us today Bill Chapman, who's a civil litigator who came across this case of elder abuse. And I found the article in the Long Beach Press Telegram that describes it in detail. And we'll put a link to the article in the description afterwards. You're welcome to read all the details, or you can just Google search Long Beach woman swindled $4 million. You'll find it. That's how I got to it. Bill is a partner, I think the name partner of MBK Chapman. If you go to mbkchapman.com, has their information, detail, contact number, phone number, and such. And you'll see all kinds of great information about what they do in their business if you're interested. This is Probate Weekly. We do this every Thursday, 4 p.m. Pacific, 7 p.m. Eastern. You can register and get reminders at probateweekly.com on the Eventbrite. We also continue the conversation in our Facebook group, Probate Weekly as well. We have 3,100 members across the country looking for referrals, attorneys, real estate agents, other probate content if you're interested in building there. And then I had a survey last week where do you get data for probate? And so we try to have this kind of content to help you build your business, be more successful. Interesting, all the leads in Probate Money tied. Probate Money is a California only product. I found it fascinating. And then Foreclosure Daily at a distant third. So I just, in terms of services, and then going to court also tied for the lead. And then I also have a real estate email marketing masterclass. I did this last month and we had great success with it. We're going to do it again in November. If you're interested, feel free to check that out. It's only $97. It's an hour-long class and 4 follow-up half hours. Lastly, all my information is on my link tree, linktr.ee/Bill Gross. And you'll see all the different things that I'm doing with me and my team and all my social media and all that. Okay, so another question that comes up to me at least is, I see advertised online identity theft protection services. To where I sit, it doesn't really affect like this kind of case. This would not have protected her, I don't think. Are you aware of these services that are being marketed to protect identity theft and the theft of your property? I don't believe, though, if she formally signs a grant deed, what kind of identity theft is going to protect her?
Yeah, I don't think so. Because she admitted that she signed the document. It was her. So it wouldn't really fall, I don't think, in the classification of identity theft. Her identity wasn't at issue here. It was, again, it was an elder abuse. It was a sophisticated real estate investor taking advantage of a little old lady in her time of need.
Man, it just violates everything that we want in our business. All of us get into this business, I think, at some point to help people. And then you watch somebody who is sophisticated take advantage of it. If you have questions, if you're on the live stream, YouTube, Facebook, or LinkedIn, feel free to jump in there. And if you're watching on the Zoom call, of course, raise your hand, put in the chat box. Don't put in any vulgar chat. I saw that guy come in the door and I knew right away. I stopped the unmute yourself so we wouldn't get the video and the pornographic video these guys are fond of putting in there, but I missed the chat box part to cut them off on there. So as investors, we have people on the call who are investors, or as realtors, we represent investors who want to get a good deal. And there are cases where a good deal is from some elderly person, 65 or older, I guess is the legal definition. Where's the threshold between getting a good deal and doing something that you know is disadvantageous to the other party?
Well, yeah, I think probably number one for me would be that you want to make sure that if it's an elderly, a fragile person, disabled in any way, they really need representation, because if they don't have professional, competent representation, then you are staring in the face of a monster. You may get bitten badly, because people who look at it afterwards are Monday morning quarterbacking or whatever. Lawyers like me, they're going to look for every possible angle that you took advantage of this person. If they have representation, then guess what? Then you ask the representative, again, not someone who's a phony representative, but a real representative to protect this individual. And then obviously the other things that we talked about that are kind of red flags is that you would want to avoid is this all has to be documented. It has to be done professionally.
Right.
And this wasn't done that way. And that's what got this guy into trouble.
You know, I saw a case, in fact, it reminds me of taking a look at this and maybe talk to you about it, where my client was selling some land. His neighbor owned other lots, and that neighbor was elderly. I want to say in the 90s, and to the point where his children tried to force him into conservancy because they thought he was selling the property too cheap. He on his own signed a contract where the sophisticated investor had a very sophisticated attorney prepare the document. So you have a sophisticated investor with a sophisticated attorney, elderly man with no attorney or agent signs a contract. They're literally in conservancy court arguing we need to prove the sale, because if not, we're facing penalties of $195,000 on $2 million property. And I thought, well, by definition, that's elder abuse, right? Yeah. Nobody signs a contract where if you don't sell a property, you have those kind of damages in today's market. That just doesn't happen unless you're taking advantage of somebody, almost by definition. So we see these cases, and again, just repeat for everybody in the call, the two standards he set were: one, they should have some professional representation, which means you as a real estate agent or somebody as an attorney. And then second, those people almost automatically, if you have me as representative, or imagine Bill, not that you do this kind of law, but if you did, you'd require some kind of documentation of some sort, whether you call it a contract or purchase agreement or memorandum, or there's a piece of paper with somebody's signature on it. I would think at the end of the day, right?
Yeah, exactly.
And that's what's going to protect everybody here. Okay. So look, I know that this is a little different topic in one regard than what we deal with in probate, but on the other hand, these are cases that maybe don't go to probate because they don't get litigated, or we should avoid these things, reasons why we should have estate planning set up, have a trustee set up, maybe somebody helping the elderly person making these decisions, the documents are done correctly. And that was the real point behind all of this. So Bill, look, I know your time is really valuable. I really enjoyed the story. I enjoyed you giving us more information in the background. Tell us what kind of cases, obviously we have on this call, and we'll be watching people who look for civil litigation attorneys. What's this case, obviously in some ways is exceptional. That's why I have you on. What's the most common case that you do business with that you bring the most value to your customers on?
Yeah, it's funny, hard to say because I really, my expertise is in the courtroom. I try cases and have tried some very large cases in multiple jurisdictions. I do business litigation, but I do quite a variety of different industries and different topics. Give you an example. If you ever hear of someone who has a legal issue relating to false advertising under the Lanham Act, where the question is relates, or the expertise in the case is stereochemistry nomenclature, then I would be your guy, because I have litigated up against Merck on a stereochemistry nomenclature case where the question was whether the capital letter L in the acronym L5-MTHF, which is metrotetrahydrofolic acid calcium salt, whether the capital letter L describes the stereochemistry of the glutamic side acid chain or the pteridine ring. So I learned these different areas. I've done fire science, a lot of fire cases in the past, products liability, securities fraud. I just did an oral argument regarding anti-SLAPP, which is First Amendment kind of stuff. So I do become an expert in different areas, but I like to get up in front of juries and courts and educate the judge or the judges in different areas. So
the whole thing with the L, capital L or not, is that like a pickup line you use in a bar to pick up on young girls? Or what? That's really impressive, Bill. We're all really interested.
Yeah, well, I should add, I've been married for 42 years to the same woman, 4 kids and 6 grandkids. So I haven't tried it in the bar, but yeah, it's a good joke. When it comes up, people say, "What do you do?" And I tell them about stereochemistry nomenclature. Then my wife walks away and says, "Oh, you can get a ride home later."
Again, actually, the one person who's not impressed with your knowledge on that matter, I'm sure, is your wife, even though she benefits from the pay from that. So, okay, so we put in the chat box his website. Again, is mbkchapman.com, and then his phone number 949-528-1077. We'll put that in the description of the video as well. And
that number, Bill, the number, I'm not sure if that's maybe a fax number or something. The phone number to our office is actually 949-767-3910. Should be on the website. So that other one, I'm not sure what number that is.
Okay, so one more time, 767.
It's 949 area code 767-3910. I'll put it in the chat.
And I'll put it in the description on the video on the YouTube as well. Bill, again, just first as a professional in the business and just as a Californian getting into the advanced stage myself, thank you for your work. Congratulations on the great work you did and continued success in getting paid for it and getting your client hopefully fully restituted and protecting. So thank you so much for your work. And second, thanks for being on the call today, educating us, realtors, investors, on really being careful. And I think the lessons I walk away with are just, again, reminders: make sure the other party has some representation to protect yourself, and make sure there's documentation of whatever you're agreeing to.
Yeah, you bet. And thanks for having me on your program, Bill. And I got to say, shout out to all of your listeners because they are really heroes as well. Because if this guy had, instead of discouraged her from getting representation, had referred him to one of your listeners, we wouldn't be here. He wouldn't have this problem.
Yeah, and I'd like to think when anybody in this call would say, "Hey, this isn't fair. This isn't done right. We need to document and protect you." Maybe the deal falls apart. That's probably why he didn't do it. Right at the end of the day, he knows, but probably it's hard to say this. There's not a realtor that would do this. I hope that's the case, but I don't know. Sometimes I'm a little discouraged with my colleagues, but hopefully on this call, we're all learned today the importance of doing things properly. So again, Bill, thank you. This is Probate Weekly. We do it every Thursday at 4 p.m. Pacific time, 7 p.m. Eastern. We live stream it on YouTube and Facebook and LinkedIn. You can watch past episodes.probateweekly.com. I'm Bill Gross. I'm a broker here in LA, California, building a national team of real estate agents focused on probate real estate. And again, Bill Chapman, thank you for your time today. Thank you, everybody, for being on the call.
Thanks.